All right, we are back on the record in 2023 CR 11452 and 2023 CR 11453, State versus Jesus Prado. Can I have parties announced?
Also, Alton State, Megan Galloway as well. Sorry.
And Ernest Acevedo and Jonathan Alvarado here with Mr. Prado, who is also present in court.
All right. And then if the jurors are ready, we'll bring them in. And I know I've already sworn you in before, but because it wasn't in front of the jury, I'll just swear you in again.
Yes, ma'am.
All right, thank you. We're ready.
All right, the jury.
All right, everyone, please be seated. Defense, you may call your next witness.
Thank you, Judge. Defense calls Dr. Jumis to the stand.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so everyone can hear. And if you could state your name for the record and spell your last name, please.
Yes, ma'am. My name is Michael Thomas Jumis. My last name is Jumes.
All right, defense, you may proceed.
Thank you, Judge. Dr. Jumis, thank you for being here. I have some questions for you. Do you know the person far to my left, Jesse Prado?
Yes, sir.
His legal name is Jesus Prado, but I know he goes by Jesse. Is this a man that you know and that you have visited and treated medically?
I conducted a mental health evaluation.
Okay. Can you tell the jury your qualifications to do what you do?
I'm a psychologist. I work in the area of clinical psychology and in the area of forensic psychology. My background is I have a doctorate, a PhD in clinical psychology, and I'm licensed to practice in the state of Texas.
All right. Where did you do your undergraduate work?
At UT Austin.
Longhorn Pen?
Yes.
Okay, good. Now, can you tell us a little bit about how your psychology practice started and where you first did some of your first rotations?
Sure. So you start practicing as a student. And so I was at the University of Texas Southwestern Medical Center at Dallas, and I was learning psychotherapy and psychological assessment, because clinical psychology really is the assessment and treatment of mental health conditions. And so that was the focus of my training. Mine is an academic PhD. I went to a medical school, but I was in a graduate school inside that, so I don't have a medical degree. So after I finished my training and while I was working on my dissertation, I started working at a brain injury rehabilitation center. I completed my doctoral work and I was in my postdoctoral year at it was a neuropsychology practice. My job there was to treat people who had acquired brain injuries, usually from like a head injury. Sometimes there was an acquired deficit from like a stroke process or maybe a tumor. And my job was to provide treatment toward improving a person's return to everyday functioning. After that, I worked in the state hospital system for decades with justice involved individuals, providing services to help evaluate and treat people to restore their fitness to return to court, or for people who were acquitted of charges by reason of insanity.
All right.
Lately, lately I'm in private practice.
Okay, and so your first doctoral experience was in that brain injury clinic, and so you had several years of working in that area with neuropsychologists, and that was your first field of practice, correct?
Yes.
After that practice, did you enter the justice system, where the justice system and your talents as a psychologist have been used in the justice system for virtually every kind of mental health issue in the judicial system?
So yeah, I've worked in treatment and in evaluation in the hospital system with juveniles and with adults, mostly adults. I worked in the maximum security hospital system and in less secure settings. I've also worked in a general psychiatric hospital as a part of my responsibilities at North Texas State Hospital. And in 2008, I came to Kerrville State Hospital, and I worked there until just the end of 23, the beginning of 2024.
Now, during all those years, that involved working as an expert in courtrooms. Is that fair to say?
Yes. Along the way, I've had a private practice, mostly evaluating competency to stand trial, sometimes some sanity questions, sometimes assisting courts or attorneys to understand the person's mental health situation, and on the criminal side of forensic psychology practice.
All right. Now, you've testified for the prosecution and for the defense. You don't take sides in your practice one way or the other, do you?
And my job is to provide an objective evaluation. That's how it can be the most helpful. And so most of my work is court ordered, and I have testified being called by defense and the prosecution. Yes.
I guess if you have been called more by one side than the other, you've probably been called as an expert more by the state than defense. Is that
Check to leading.
Sustain.
if you know, do you think you've been called more often by the prosecution or by the defense in cases that have had court issues?
In cases that have court issues, usually my involvement is to help establish whether somebody's competent to proceed or competent to stand trial. Sometimes a mental health condition can interfere with a person's understanding of court or their ability to work with their lawyer. So usually when I recommend that somebody is incompetent or not fit to proceed with court, no one disagrees, because there were concerns. It got evaluated, and in general, the court opens the doorway to treatment to help a person improve their readiness for court. It's mostly when the results come back where the person is competent, and maybe the defense would disagree that there'd be a trial on the issue. And so most of my work is in the area of competency to stand trial evaluations. And so most of the time I'm called by the state to testify in those cases, again, under a court order.
Okay, did you get asked to evaluate Jesse Prado at some point? I guess a couple of years ago.
Yes, in 2024,
Well, did you do that?
I did.
And he's been in jail during that time. So like, what's the process for a doctor when you have to evaluate somebody in the jail?
So I think I've met with him. Well, I know I met with him 3 times. Once in the beginning of July, it was July 7th of last year, and then again on July 30th of last year, and then again July 31st of this year. So I've had 3 meetings. I want to recall that 2 of them were in an attorney booth with the glass kind of between us, but the second meeting was in a conference space at the jail.
So when a person's getting doctoral evaluations, there is a way you can get more freer access than like I would. Where you can actually interact with somebody, evaluate somebody medically if you need to.
Yes, psychologically.
Psychologically, I'm sorry. Okay, now in the course of that, I mean, you have to get a history for a person, correct?
Yeah, the history is the platform on which the case develops. And so, yeah, a history would include things like growing up and relationships, school, work, health, mental health.
And additionally, because there's a criminal element to it, did you get basically like the prosecution guide of the offense so that you could have the context of what he was accused of doing?
I did. So I had some written law enforcement reports, as well as a body camera worn video recording of the events that I think lead us here today.
Okay, and so, yeah, it's on. Can you hear me? I just have to sit forward. So during your evaluations, you had access to the reports and the videotape, the same ones that have been introduced into evidence, or at least certainly contextually. The videos that show shootings and interaction with the police on the day he was charged with a crime.
My review was limited to the body worn camera that one of the officers had that captured coming up to the house, and then an exchange of gunfire and his retreat to another house where he was able to get care. So my review of that was limited. I think, as I remember now, I also reviewed a video of an investigation interview with Mr. Prado shortly after his arrest, as I recall.
And that's the statement with the detective you're talking about?
Yes, I think so.
Okay. Now let's talk a little bit about the history. You did learn through your evaluation that Mr. Prado had lost his brother, and that was a pretty devastating loss for him. That's part of the history that you took from him. Is that correct?
Check reading.
All right, you can finish your question.
Is that part of the history that you got from him?
Yes.
As a psychologist, I guess you have a large amount of training on depression generally. Do you agree with that?
Absolutely.
Okay, can you tell the jury just the basics of what depression is and how it can affect a person normally?
Depression exists in different forms, and there are a range of conditions that I think generally we'd think about. One would be, you might think of grief that happens if we lose a loved one. And another would be something like what mental health professionals call dysthymia. That's this idea that a depression is kind of part of a person. It's kind of chronically experienced. It's in some ways it has been thought about as like a depressive personality style. And that, for our purposes, that's an okay way to think about it, although I don't know that technically that's exactly right. And then there's something that we call clinical depression, which is what we think more about in terms of a biological kind of reactivity to a lot of people, the health community talks about the level of serotonin in the brain. And so one focus is biological. And depression can express itself in like hard to sleep. I've got insomnia, or my appetite changes, my energy level changes. And then there are psychological qualities like the subjective feeling of sadness. I'm blue. My self-esteem might change. I begin to question things. The things that gave me pleasure in life don't do that anymore. And so there are tagging kinds of consequences for some of that can start to impact a person's even work performance, their focus of attention and concentration, their ability to remember things smoothly and easily. They can lose efficiencies and not have energy to like take up roles that are familiar, like parent or spouse or things like that. So there's a range of responses that I think we would lump together and think about like depression.
Now, would you agree that, I guess, for people that don't understand depression as clinically as you do, that there's still a stigma, do you think, in society that when somebody's depressed, clinically depressed, that they don't look at it the same way as if somebody has cancer? Like it's just like, hey, toughen up. Versus when somebody has cancer, nobody ever tells a cancer patient like to toughen up. Or do you understand what I'm asking?
You know, there is a stigma to for people who deal with serious mental illness, and depression in some of its forms can be very serious. It can be life-threatening. It can contribute to suicide. So, but the stigma about a person's ideas of who they are, or maybe family forces, or you know, there's a larger culture, and then there are these sort of microcultures that we live in, and some of that's our family and maybe our circle of friends, or the kind of work that we have, or aspects of our identity that can really impact different people different ways.
Now, through your history, it was part of your history, did you learn whether he was taking depression medication at some point?
Yes.
What was the history on how he was medicating?
So he lost his brother, and that was some years earlier. And then he was in the process of a divorce within the 6 or 9 months of the arrest situation. And so during that late time after the divorce, he was taking Zoloft, which is an antidepressant medication. But his understanding about taking the medication had more to do with his experience. He talked about anxiety as the principal reason for the Zoloft. And depression and anxiety go together a little bit like peanut butter and jelly. And so there can be anti-anxiety effects from taking an antidepressant medication. So that kind of hangs together.
Now, did he get this through traditional, like, hey, let me go see my doctor, or did he get it off the internet? Do you remember that?
I recall it was the internet in his case.
So his particular prescription didn't really come with a doctor visit or an office visit, but it was, I mean, do you remember the website he got it from by chance?
I think it was hims.com. And in my training, we would expect to see medication as a first line, sometimes by a general practitioner. But as depression settles in, sometimes a person needs other treatments too. I'm not sure those were there.
And I guess as a practicing psychologist, would you agree, as a general question, you're better off seeing a medical professional, psychologist or psychiatrist, to treat your depression versus getting it on hims.com? That would be the better course of action?
I would tend to think so. I don't know a lot about everybody else's practice, but I know in the work that I do, COVID affected everything. And there was a time where I was doing televideo interviews, and I've abandoned that in my practice over the last couple of years to see people in person. which just helps me do my job in a way I think is better.
Okay, in the history, part of the history was also, I guess, how Jesse was dealing with marital problems. What history did you take about marital problems he may have been having?
Yeah, that for me began earlier. So the trellis on which I think a case kind of grows is to understand some things earlier on. In his case, he was in a large blended family. And at some point in his growing up experience, I want to say seventh grade, his stepdad went to prison. And that was a disruption to the family. And I think he experienced that with failing a grade. So being held back, there was a disruption, not only the family took it in that kind of way. And then his big brother, several years older, stepped into the role, kind of like a surrogate father figure. So there were some mixtures, clinically, about the role of father, the complexities of having a blended family and a stepdad leaving the household for prison, and then his brother stepping in to really help the family, support them financially and emotionally. And then over the years, they were close, and then his brother died unexpectedly.
Okay, so that, I mean, did that explain where some of his depression could have come from, that experience?
Well, I think that those things coalesce. And for him, he was able to function, but he was experiencing that loss. And it's somewhere in the space between grief and clinical depression that I think he was kind of harboring. And at that time, after his brother's passing, his condition was untreated.
So then if we move on in his history towards his marriage to Monette, did there become problems in his marriage to Monette, a year or so after his brother passed away?
Yes.
Um, did you take a history on just knowing, like, I mean, the details of like how the basic problems started in the marriage?
Yes. So Mr. Prado, he was a teen dad, and for me, that's an important contextual element. He was in a relationship with his son's mother. He was 15. He dropped out of school. He took work in support of the household, and they were on again, off again. So the relationship eventually closed. He developed a relationship with his wife. It was a long relationship. I think it spanned a couple decades, and maybe 10 or 12 years in, they married. They were married until after his arrest, and I guess the divorce finalized. They were in the process of a separation, and he was contending with really the loss of the marriage in the throes of an infidelity partner situation.
Did that affect him, I guess, on top of the distress he was still feeling about his brother?
I think it did, and it's in regard of I think areas of his identity, his emotional responses. He subjectively sort of understood it as anxiety, so he, like we talked about, took Zoloft. I think it affected his work. He began to struggle at work. He had a work problem, and he was an over-the-road truck driver, and he had a driving event that was suggested maybe he was nodding off at the wheel, and I guess there's cameras in the trucks to alert the companies about that. So that became a focus of things. He had to step away from driving and start getting some health care, and disrupted his earnings. And there's just sort of this cascade of situational forces that were kind of coming on: the dissolution of the marriage, and the work stress, and the financial press on top of that, and family and children, and house management.
Okay, so now I want to ask you a psychological question about infidelity. I guess infidelity is another thing. Can it be like like the issue of depression, where there can be a stigma with it, where infidelity will affect some people more than others, and it can have a profound impact on somebody?
There's a lot to, everybody's different. That's one main point. I'm looking at patterns to try to understand, and so I think the short answer is yes. But when I think about Mr. Prado, I think that he experienced a tremendous impact from the relationship breaking, and yeah.
I guess if we're going to talk about psychological factors, the next one I would want to ask you about is the breakup of the family unit, like the idea of losing the house, losing primary custody of the girls, things like that. Was that something that came into play very shortly before this arrest?
I think so.
And what kind of psychological effect can that have on a person?
So I think a way to understand is that that the an infidelity situation, again, different people react in different kinds of ways, but there's an emerging literature on the traumatic experience that a person might take when they're contending. There are responses people have: can't let it go, loss of trust, replaying the loss, the fantasy, what happened between the two. There's just a cascade of reactions that can happen, and I think for Mr. Prado, he was experiencing areas of concern for who's going to raise the kids, who's going to get the house. I think he was taking steps to try to salvage the relationship, but was unable to do that.
Now, I guess if we're going to talk about psychology in general, I mean, most everybody in their life experiences some kind of close loss. I mean, death comes to us all.
Yes.
And so some people can deal with the death of a loved one pretty well and not have any completely disruptive psychological episode. Do you agree with that?
Absolutely.
Some people can deal with infidelity and move on like nothing.
Absolutely.
And people have a divorce and lose custody of their kids and lose their house and their retirement and deal with that normally.
Yes, many can.
Do some people have a much bigger problem with that?
Yes.
And if it's a psychological problem, like if a person is having a psychological crisis, is that something that's easily controlled, like by decision making?
Well, by virtue of the word crisis, we know that the answer is no.
Now, I want to go back to the history, because I guess there's one other factor that I know you've brought to my attention. When taking the history, did you find out he had been involved in some pretty serious accidents?
Yes, part of the history uncovered a couple of serious head injuries.
Now, why did that make you think to investigate that more when you're doing your evaluation?
Well, there were a couple of reasons. Really, the main one was that from a mental health perspective, there's only so much in this case. There's not a severe and disabling mental disease like schizophrenia at play. There's a lot of things that aren't there. So the question is, how could someone understand this event and the aspects of judgment involved, what might help understand what vulnerabilities this person might have to better understand that incident. And the head injuries, the history of head injuries, led me to wonder about his cognitive functioning. And I always screen cognitive abilities in a mental status examination. And when I say cognitive, I mean, is the person alert and attentive? Do they, how's their attention and concentration? Is their memory functioning normal? What about judgment, information processing, and insight? And so when I did the usual mental status examination, his results were clean. And I was just puzzling over how could he have this history of head injuries and return this particular mental status examination. And so I evaluated further in my second interview, and I used some screening tools for broad cognitive abilities and for intellect and for sort of judgment and executive cognitive abilities. And everything returned as you'd expect, kind of in the normal ranges, except for a screening measure where the test is built in such a way that it increases situation demand. There's a test situation, and so there's kind of a baseline measure and a secondary measure with additional complexity. And his performance was slow, and it was erroneous. And so that was where the results were leading in terms of trying to understand whether there was some cognitive area of vulnerability in this case. And so that's how that was uncovered.
When you say his scores were unexpected on that particular area of decision making, by how much? Are there mathematical terms that y'all use to determine that?
Yeah. So a way to think about it is the normal curve kind of establishes an understanding of what's a normal limit. And so in his case, his performance was 2 standard deviations slower than people his age. And he had a kind of a retracing correction that he'd made so that his decision making was inflexible. Well, it was flexible enough in that he realized the mistake and he corrected it. But he had the test kind of pulls for flexibility, speed of response, and synthesis of visual and motor skills. So it's rich in involvement of executive cognitive abilities, and that's where those findings led me.
Now, as a psychologist, and I guess your history treating brain injury patients, the decision-making part of the brain that you're talking about, where he tested for deficiency, what part of the brain causes, or what part of the brain does that exist?
So the test is pulling for executive cognitive abilities, and those are housed in the frontal lobes of the brain. That's the part of the brain behind your forehead.
Okay, now, if a person is knocked unconscious, that is by definition considered a traumatic brain injury, correct?
Your Honor, I'm just gonna reiterate my earlier objections
All
about
right,
this
that'll-
being outside the scope of his expertise.
All right, that'll be overruled.
Yes.
All right, now, in his history, did you learn that he had been in an ATV accident where he was knocked unconscious for a long period of time and had to be airlifted to Wilford Hall Medical Center?
Yes, he was, I think, 19 at the time.
Is that the kind of injury, by definition, called a traumatic brain injury?
Yes.
And when that happens, according to your training, does that mean somebody is going to be deficient in the future, or does it mean that people react differently to different kinds of injuries?
It doesn't necessarily follow that if someone's had a serious head injury that they're going to have lifelong uh, uh, disability. There's a window of natural healing that occurs for people, and that's a wonderful thing. So we always expect that a person will improve after an acute head injury, and in that window during the improvement, you don't really know where it'll land. And a lot of people, depending on severity and other factors, can enjoy good recovery, even full recovery.
Are traumatic brain injuries worse when they happen more than once?
Yes, and the data suggests that once a person has a history of a traumatic brain injury, they're vulnerable to subsequent traumatic brain injuries.
I mean, you're familiar with what CTE is, correct?
Somewhat.
Okay, and some of those things, as far as diagnosing them, cannot be diagnosed without an autopsy.
Again, Your Honor, he said somewhat, so I'm going to object to him asking questions about something he's not familiar.
All right, that objection will be sustained.
Doctor, I want to show you what was marked as defense exhibit 2 and 3. Now, you did get a history of Mr. Prado being involved in a second accident, a bad rollover accident,
Yes, through a culvert.
but you hadn't like seen the pictures of the accident.
That's correct.
Just a history from him.
Right.
So this is defense exhibit 2 and 3. That's been introduced into evidence, so the jury has seen that already. What does that appear to be to you?
Oh, no. This 1 second. Do you need water or cough drop?
No, I'm sorry. I'm sorry.
Oh, no, you're fine. Take your all the time.
And were you all able to hear the last question and answer? All right, you may continue.
I mean, if it's come out into evidence that this is the rollover results from that accident, is that also consistent with traumatic brain injury if the testimony is he was knocked unconscious during that accident as well?
Well, I would think that it just demonstrates that it was a serious collision, and with those kinds of collisions, there's movement inside the skull. The brain is surrounded by a kind of a layer of tissues in a fluid layer, and so it's sloshing around. And it would look like here that there was multiple impacts, so that there was a lot of dynamic movement inside the cab of this vehicle.
Okay, and that would be consistent from the history that you took from him as well. Just that there was a period of unconsciousness in this accident as well.
Yes.
Second traumatic brain injury.
Yes.
Okay, so like after discovering the deficits in your testing, what normally happens after that if a person has more resources and more freedom? Like, what would you recommend as a psychologist once you see that he has screened for cognitive deficiencies in his frontal lobe that are inconsistent with his intelligence? You've gotten to that point. What do you normally do after that point?
So I would refer him to a neuropsychologist and a neurologist. The difference being a neurologist is a medical doctor whose training and experience and practice will afford a medical course of care, which could include things like medications or other strategies. And a neuropsychologist, because the role of evaluation in a case like this would help establish the patterns of relative cognitive strengths and weaknesses, and understand their functional implications to really make a roadmap for a course of care.
Psychologically speaking, is further evaluation and treatment something that would benefit Mr. Prado as a patient?
Yes.
Now, the Bexar County Jail, I mean, the Bexar County Jail is not MD Anderson, right? I mean, you would agree with that. I mean, I don't mean to make lightly of that, but you get emergency treatment at the jail generally, correct?
There are healthcare services at the jail, but they are in the area that we're talking about, to uncover what would be some subtle signs and understand their long-term impact and make an intervention. Those are not they're not available at the jail. They're just not.
Right. As far, I mean, this would be, this is not emergency medical treatment. This is just what you would recommend for somebody in this situation if they had the resources to treat it. Right.
Absolutely.
The jail is not going to take a prisoner to a neuroscientist or a neuropsychologist without some kind of a pressing emergency need. That's just the way the jail works. Would you
If someone fell in the cell and were knocked unconscious, of course they get emergency care. But in a situation like this, that's highly unlikely.
Okay, so now I'm going to ask you a few questions about October 19th, 2023. I mean, you know factually what happened from the reports and the videos, correct?
Yes.
You do know that Jesse Prado accepted responsibility, pled guilty to the jury when they read the charge, and this trial is solely about what punishment is appropriate for him. You know that, right?
Yes.
You know, a question that I asked you a long time ago was just saying, you remember me asking you, I want to understand what happened that could make a person with so inconsistently in this environment do something this ugly. Do you have opinions on that idea? How does a person with such good history throughout his whole life get to the point where they make such a terrible decision with everything you know in your evaluation of Jesse Prado?
Yeah, defense counsel raised the issue that he just snapped, which psychologically is a little unsatisfying to me because that's almost like saying kind of out of the blue, this terrible thing happened. And so it's important to kind of think through. I mean, if I could let you borrow my thinking for a minute, the major context and a major tension here for all of us is that psychology and the theories and the practice and assessment, they're all based on a model that we should call determinism. The idea that there may be some biological vulnerabilities that get expressed in a person's behavior, or there may be some psychological events, some things that happen to someone that shape the why and wherefore. We rely on those things like all the time in all the books about how to raise your children and things like that. And then there are just things that happen to people that we have to contend with. And so the model I operate out of is kind of gray and deterministic. And the question is, how does somebody just snap, right? So that's about cause, and I can't answer that, and I don't know that psychology has a great answer to what caused this, which is a tension here, and so what I can say are some of the conditions I think that added to understanding his vulnerabilities for that judgment. And some of those, I think, are really a backdrop of long sadness over his brother's passing. That's just an operational force, but in general, sadness doesn't add to highly activated events. It more turns us inward, or it makes us slows us down. Other mental health constructs have to do with understanding the impact of trauma on like reactivity for decision making. And in general, under stressful conditions, that's not the time to make really big, big choices. A lot of people are counseled maybe to don't sell your house after your spouse dies. Wait a year. See it from a different perspective over a little time if you can. So, we know generally that emotions affect judgment. And then there's this history of a head injury and a test result that points to the probability that there's vulnerability with decision making under pressure. That is a part of the constellation in understanding this particular case. And that really is how things coalesce. As I thought about being involved and I thought about trying to help figure out about whether someone snapped, I think the data pointed more to just these three things.
Now, as a professional psychologist and somebody who testifies in court, you're certainly not trying to excuse his actions, correct?
I can't explain it, let alone excuse it. I certainly can't.
He certainly doesn't rise to the level where he wouldn't be criminally culpable for it. Like, he certainly was not legally insane. The definition for that is very strict. Clearly doesn't meet that definition, right?
Two or three things. I wasn't asked to evaluate that, but just in general, the idea is a person has to be have a severe mental disease or defect in order to raise the issue. And in this case, I don't think you meet that bar.
And I mean, I guess by definition, him pleading guilty means he's accepting the responsibility for the crime he committed.
Leading and counsel testifying.
Sustained
I'm sorry. Leading and counsel testifying.
and sustained.
One statement I wanted to ask you about is that there was testimony from one of the only eyewitnesses to Jesse right before the police got there. There was testimony from his wife, Monette, that when he found out the police were called, she said his eyes glazed over in this way that she had never seen before. Is there any psychological explanation for that you can see as a possibility?
Well, I have a couple of reactions to that. One is I wasn't in that moment. I didn't see that to sort of experience it. I have seen people in clinical situations where it looked to me like that there was a change in their gaze that usually one of the hypotheses I have about that, it's kind of the educated guess stuff, right? It's about whether they're re-experiencing some kind of trauma. That'd be one. Clinically, that could lead to questions about dissociation. It could lead to questions about, contact with reality. I don't think the rest of the data in this case bear out much about those other things. But I think that just, putting things together, the more likely clinical area to explore is that is a reflection that that the situation demands were outstripping coping resources. And so the emotions and the situation were overwhelming.
I'm sorry, if we could just have 5 minutes, please. And I'm going to have the jury, if you can step outside just briefly. Just we're ready. Thank you.
All right to the jury.
All right, everyone, please be seated. And defense, you may continue.
You Judge. Doctor, you know there is a retribution angle towards punishment, correct?
Relevant.
What is the relevancy?
Well, I was gonna say that. Yeah.
Could I have parties
Yeah,
approach?
that would be easier, Judge. Doctor, let me rephrase. Do you agree that rehabilitation is one aspect of punishment in a criminal case?
Certainly can be. And from a mental health perspective, it ought to be.
From the rehabilitation side, and your expertise as a psychologist, could Jesse Prado receive benefit from treatment and rehabilitation for the issues that he's been through that you're aware of?
I believe you would.
As far as the other aspects of punishment and the other reasons for it, do you really have a strong position on the other issues?
I do not. They would be apart from mental health.
I have no further questions, Judge.
State?
Yes, sir. Good afternoon, Dr. Jones.
Good afternoon.
I guess I want to start out by just clarifying your background and your qualifications. So you told us that you're a psychologist, correct?
Yes.
Okay. And you have, I think how many years have you been a practicing psychologist?
Well, I got licensed in 1997, and so that's like 28 years.
Getting up on 30 years.
Yes.
In those 30 years, you have, I think you said about 3 years working on the brain injury side of things. Is that correct?
In treatment, yes.
Okay. And that was at the very beginning of your career in the 90s, correct?
Yes.
So ever since you left that field in 1997 or 8, is that correct?
Right.
You have been doing sanity evaluations and competency evaluations on the criminal side of the justice system, correct?
Well, so I've done that along with other things, yes.
Predominantly sanity and competency is your main area of practice.
Yes.
Okay. And the brain injury stuff that you did early on, that's not an active part of your practice anymore, the treatment and diagnosis or analysis of brain injuries.
So there's a couple of things to that question. So when I worked at the Brain Injury Rehab Center, my responsibility was on the treatment side of a practice that had assessment and treatment. I didn't do assessment there. But the question had to do with both treatment and assessment. And in psychology practice, every day, my responsibility involves evaluating how a person is thinking and feeling and behaving and responding. And that includes understanding things like memory and concentration and problem solving and practical judgment. And so every day I use the concepts of those things. in
Right, that's
practice.
not brain injury, correct?
Well, they're the evaluation tools that you would use for people, whether they had brain injuries or not. They're-
Right, I'm getting that is you're evaluating and treating or assessing the cognitive issues, not the causes that led to the cognitive issues.
Fair.
Okay. And so in that same vein, the proper, I guess, medical professionals to diagnose traumatic brain injuries or physical, medical, physiological injuries to the brain, frontal lobe injury, TBI, whatever it may be. That's not a psychologist, correct? That's a neurologist, a neurosurgeon, possibly a neuropsychologist.
So a neuropsychologist is a psychologist, and a neuropsychologist can certainly help with diagnosis. Just the disciplines are different. The evolution of the practice of neuropsychology is interesting, but here's the cliff notes. It used to be that we didn't have computer aided imaging, so MRIs and CT scans didn't exist. And it was neuropsychology that was establishing localization of deficits and the brain behavior relationships that you couldn't see in an X-ray. So in the inception of what we're talking about, it was neuropsychology and not neurology that was doing the diagnostic heavy lifting. So I just think that it's important to sort of understand the right roles for the partnerships across the disciplines that are needful for understanding the etiology or the causation of the results that I'm left to sort of unpack.
Sure, and I come back to, you're not a neuropsychologist.
I
correct?
am absolutely not a neuropsychologist.
Okay, so that's what I'm getting at. You are not the right medical professional to diagnose physical medical injuries, correct?
I would tend to agree with that. Yes.
Thank you, okay. So talking about your previous experience testifying in courtrooms, I understand that you've done that several times for our office and other offices, other sides of the table.
Sure.
In all of those times that you've been qualified as an expert, that have been in the area of sanity and competency, correct?
Probably.
And that's not what we're here for today, correct?
Correct.
Okay. And I think you said on direct examination that there is no indication that Mr. Prado has any severe mental disease or defect that would render him incapable of understanding the seriousness or the consequences of his actions that day, correct?
I would agree. That's correct.
Okay, so if a person were deemed insane, which again, to be clear, not here, if a person were deemed insane, and by that reason, they are not guilty of the actions that they are accused of, that person would then be potentially committed to the state hospital, correct?
Very often, yes.
Okay, so in a case like this, where the defendant very obviously understands the gravity of what he did and understands the consequences and acknowledges that he did so intentionally, the only options left for us to punish and control that person's behavior are prison or community supervision. Is that correct?
I would think so.
And when you evaluated the defendant, that was not at the time that he committed these offenses in October of 2023, correct? It was about a year later that you started doing your evaluations?
July of 2024. Yes, that's right.
Okay, and so everything that your evaluation is based on what he told you and what you saw in the evidence that was provided to you by the defense. Is that correct?
And the results of testing.
Okay, and we'll talk about that. But I want to talk a little bit more about the history that you said you were given in order to help you conduct your evaluation. You said that you were given police reports, you were shown one body camera video. And you saw his interview where he talked to the police about what he did, correct?
Yes.
Okay. And again, in that interview, you didn't see any issues with any cognitive decline or cognitive slowness, for lack of a better word.
Not from those, no.
Okay. And that was at the time he committed this offense, correct?
Yes,
Okay.
videos, yes.
Did you talk to any of his family members or friends?
Did not.
You did not. So your entirety of information regarding those accidents that he was in, early on, how they have affected him ever since, the loss of his brother, what he's going through with the divorce, that was entirely based on what Mr. Prado told you.
Yes.
One moment. The testing that you did on him, tell us a little bit more about that.
So there are gold standard tests, and then there are screening tests for things like intelligence. And so I used a screening test for intellect that has measures of verbal and nonverbal problem solving and gives a composite IQ estimate. And that came into the normal range with no relative strengths or weaknesses from a measurement perspective in areas of verbal and nonverbal reasoning. And I used a broad screening tool for cognitive abilities that had areas for immediate and delayed memory and attention and language and some visiographic kinds of skill areas. The results of that were largely consistent with his performance in the intelligence test, which is kind of an important watermark for understanding where there might be relative cognitive strengths or weaknesses. In his case, he had a relative better score in areas of language skills, and it was not so remarkable. It was just a notable sort of difference. There was a little variance in scores. The combination of the two tools helps me to appraise whether he put effort forth in the testing situation, and the consistency and some of the ways that the inner workings of the test kind of fall out. There was effort in his performance. Because the neurocognitive test or the cognitive abilities screening that I used, it doesn't have much in the area of executive cognitive functioning. Because of the history of head injuries and because the case was turning around the question of judgment, I added a measure regarding flexibility for kind of a visual graphic task under a time demand. And there's two parts to that particular test. And in the first one, that kind of provides a baseline of skills, his performance was perfectly normal. And then the second one, his performance was horrible. And so that's where the data began, kind of falls out to suggest there is an area of thinking skills for him that is affected, and it's about decision making under demand, which is an executive cognitive ability, and for him seems to be a vulnerability, and it merits further diagnostic workup.
So you said decision making under pressure.
That's right.
And to be fair, any adult in the human race at some point or another is faced with possibly having to make hard decisions under pressure, correct?
Absolutely.
And you said that the results of that showed that he was 2 standard deviations slower than the people of his age?
That's right.
Okay. How many possible deviations are there?
Well, the normal curve flows to infinity, but we think about it in terms of 2 standard deviations or 3 standard deviations. So most scores fall within 1 standard deviation. 68% of scores for that test you would expect to fall within 1 standard deviation. Scores that fell higher or faster performance are just, that's not what we're talking about. So those kind of fall off the table. It's the scores between the first standard deviation and beyond where you start wondering, where's the borderline? 2 standard deviations away from the arithmetic mean is a score where 5% or fewer people produce scores in that area. So if you think about it in rough terms, it'd be like his performance was worse than 95% of everybody else in that particular area. That's how you'd interpret that.
So he's a bad decision maker.
So for that cognitive skill set that this test is aiming at, he performed in that way. There are a lot of things about decision making that go into decision making, but there's a vulnerability there, at least suggested by those scores.
And that's, I think you just said, if I'm paraphrasing correctly, that's just one small facet of decision making. He scored very poorly in one facet of
Yeah, because I only tested that.
it. Okay.
Yeah, there could
So
be
you
more.
can't get the data about any other deficit that he might have in that regard.
I'm not a neuropsychologist. I was looking for information, whether it existed or not, in terms of what might help understand his vulnerabilities in areas of judgment. And that's what we're talking about today.
And for someone to score, I guess, apart from the norm, again, you've already told the jury you're not qualified to say like what physical injuries may cause that, but is that something that could only be caused by a physical injury, or is that something that could be caused by brain chemistry or genetics or anything like that?
That's a great question.
I guess what I'm getting at, he could have been born like that, correct? That doesn't necessarily mean this is a developed condition.
I would agree with you. That's possible.
We're talking about the accidents that he was in, you didn't review any medical records from those accidents, did you?
He signed a release of information for me for those. I understood that he was treated at Wilfred Hall, and I pursued those. And I got a notification back from the hospital that they didn't have those records. So I don't know how to understand that.
Okay, so again, you don't have any medical records that played a part in your evaluation of Mr. Prado regarding those accidents?
That's correct.
Okay. And the pictures that defense counsel is showing you about the car accident, you said that those are really just indicative of how serious the accident is, but those in no way tell you, nor do you have any data to tell you that he did in fact suffer a traumatic brain injury in those accidents.
Only by self-report.
Okay. Now, when we're talking about self-reporting again, because you don't have any information from anybody apart from Mr. Prado. So what did he tell you about what his life was like after that last accident? We've already heard testimony and established the last accident, the one with the pictures that you saw, was about 16 or 17 years ago. So what did he tell you about what his life was like after that accident?
He was married. He had work. He had a family. He was, I think, in a spot where he was proud of himself.
And he didn't tell you that he ever had any issues with outbursts or emotional dysregulation or cognitive impairment of any sort?
That's right.
And you have no information from that, about that from anybody else, that he had any issues over those 16 years until we got to October 19th of 2023.
That's right.
And you talked about, I don't wanna, I may have wrote this down wrong. Patterns of relative cognitive strengths and weaknesses. You were looking for that in your testing with the defendant, correct?
Yes.
Okay. So you would agree with me that patterns of behavior are important in assessing a person's mental function?
Absolutely.
One moment. And you also mentioned the brother's passing having been a significant stressor for him.
Got lost for him. Yes.
Okay, and you would agree that that was 2 years prior to this incident, correct?
As I understand it, yes.
Yes. And again, there were no reports of any outbursts, cognitive dysregulation, temper tantrums, poor decision making from the time he lost his brother until this happened, correct?
He talked about feeling guilty that he was not able to accomplish certain things like to bury his brother. And he became tearful when he was talking about that while we were together. I was struck that he was still quite sensitive, even in the situation we're in, to have that kind of reaction during our meeting.
He was grief stricken.
Ongoingly, it seemed, yes.
I mean, it only been 2 years. I feel like losing a person you love could affect you forever, correct?
Yes.
Okay, but again, no outbursts of the sort that we're talking about here, or examples of bad decision making or inability to regulate his emotions.
That's what's so difficult in this case is it's a pattern of one. And so a dot on a page doesn't coalesce into a pattern. That's what's tough about this case.
But it's entirely possible that it's consistent with another explanation, isn't it?
Yes,
Okay, so
there's always things to learn.
Sure. So I'm gonna show you what's been admitted into evidence in State Exhibit 1. This is a screenshot of a text message exchange from January of 2023 between the defendant and his then wife, Mona Ellis. Were you shown any of these text messages in your evaluation of the defendant?
No.
So this is January 23. This is about 9 or 10 months before the shooting, okay? You'll see at the top of the text, he says, with exclamation points behind it, "We need to put it on the market before I burn this bitch down." And then he goes on to tell Monette he's not gonna be her roommate. And then about 7 hours later, his attitude from being angry and argumentative changes to, "I don't want to divorce Monette, I meant my vows." You see that?
I do.
Okay. And then she doesn't respond within 8 minutes. And he turned back to, "You're cold-blooded, really thinking about burning this house down right now." You see that?
I do.
And so could that pattern of communication be consistent with not somebody having a cognitive dysfunction, but just being unhappy that they're not getting their way?
Yes, and both.
I'm gonna show you State's Exhibit 4, which is again another text exchange. I know this doesn't have a screenshot, and I know defense counsel would correct me if I were saying this incorrectly, but these are texts that were between the defendant and his wife the day before and the day of the shooting. So these would be in October of 2023. Okay. Sorry, you with me?
Yes,
Okay.
I don't see a date.
No, I know that's what I'm saying. This screenshot doesn't have one, but testimony's already been elicited that it happened in October of 2023.
I see.
I
what
just
you
wanted
mean.
to let you know.
Thank you.
Clarify, is this the one, the day before, day of, or day of, and day before?
All right, so this is what I'm gonna remind everybody, everything that everybody is saying, the court reporter has to take down. So she can barely hear what's being said from what I'm reading on her live. So if everyone can remember to speak up and not talk over each other.
Yes, ma'am. Yes, you're correct. So at the top of this message, you'll see him starting out telling Monette that she's gonna regret this. And accusing her of causing a bunch of hurt. And then at the bottom of the message, he says he's doing his very best to be gentle. He doesn't want to get emotional and blow up on the woman that he loves. And then he starts telling her that she's better than other people in their lives. You see that?
Yes.
And then it states exhibit 7, which is a continuation of the same conversation. He's telling her that he is sexually frustrated and that she knows this is how he gets. And then she doesn't respond, and he switches to have it your way. You blame me, I blame him, I'm going to go kill that motherfucker. Do you see that?
Yes.
So these text messages could be, and I'm not asking you to tell the jury what they mean because you don't know what was going on in his head at the time. My point is, these text messages and this pattern of communication of being friendly and polite or asking for something and then not getting his way and then lashing out. That could also be consistent with the behavior that we're seeing, not just cognitive dysfunction.
Would 100% agree.
And since you didn't talk to his family, I don't guess you would know that his daughter says that. Well, let me back up. Were you told by Jesse, that. I guess the kind of back and forth that there was with Monette when she moved out in January, but then would still kind of spend time with him, between January and October. Such that he was still kind of hopeful that things could, get back to normal. Did he tell you about that?
Yes, ma'am.
Okay. So in that first text message I showed you where he was talking about burning the house down, that was in January, correct? And then his daughter testified that there were no real issues between her father and her mother from January, when she started coming back around, until this happened in October. So again, is that consistent with him lashing out when he's not getting his way? But when she is around and he's getting his way, things are okay, things are calm. But then as soon as she makes it clear in October, she's done, then he's done. Is that consistent with that behavior?
I don't mean to be difficult. I don't know that I understand your question. Is that consistent with that behavior? I don't know where the linking is.
Okay.
I see what you're saying.
I'll rephrase it. We see a text message where he's lashing out at Monette in January,
Yes.
correct? And then there's testimony from his daughter that after that happened, things calmed down between the two of them because she is around.
Yes.
Okay. And then we see him lash out in October at these innocent law enforcement officers who were just there to help. And the timing of that is at the same time that Monette has kind of told him, I'm done. Do you see the connection there?
Yes.
Okay, so is that behavior just as consistent with somebody simply being unhappy that they are not getting their way, as opposed to a cognitive dysfunction due to brain trauma or head injury or depression?
Yeah, I think that certainly was at play in the situation. Yes.
You talked about.
I regret the phrase I use. There's nothing play about what we're talking about. And yet I think what I mean is we understand.
You talked about depression. Do you have, given that's, I think, probably a major part of your field, correct?
Well, it's one of three constellation mental illnesses. Yes, mood disorder.
Do you have any idea just roughly how many members of the population suffer from depression?
Depends on the definition. It's the most common mental illness in the United States.
More than half
Oh,
of the population?
if you're talking about clinical depression, I'd say no, be much lower than that.
Just generalized depression?
Well, I don't know what generalized depression means. The sadness of situations of living, 99.9%. Everybody has times like that.
Did you diagnose the defendant with clinical depression?
No.
No, okay, so he's not clinically depressed.
I don't think so. I think he's had more of a complex grief reaction,
Okay,
which embodies qualities of subjective depression and some of its outcropping kinds of qualities. Yes, ma'am.
okay. But the kind of, I guess, depression that he suffers from is the kind that affects the majority of the population.
I'd say no. I'd say that grief reactions tend to be short-lived, and people can kind of get over them on their own. And one of the complexities in this particular case is that we add in the timing of his marriage beginning to unravel and its implications for understanding this.
And again, the timing of his marriage beginning to unravel was 2 years after the law.
Yes, and 2 years is a long time to grieve.
And he discussed with you anxiety, is that correct?
Yes,
And anxiety also affects a significant portion of the population, doesn't it?
it does.
As does grief and non-clinical depression.
Yes.
And there are no safeguards in the world that you know of that can prevent a person from experiencing any of those things at the same time.
That's fair.
And you said that these things that he was dealing with, the depression, the grief, the anxiety, these were all normal things that occur to lots of people, correct?
Yes.
And some people can deal with them and some people can't, correct?
Yes.
So for those who can't, are those of us in society, the rest of us who can, are we to bear the burden of those who cannot?
I don't know how to answer that.
Would you feel safe living in a society where those people who cannot handle the weight of these types of normal occurrences and whose reaction, because they're just a bad decision maker, is to hurt other people, that they were allowed to live amongst us in society? Would you feel safe?
I work in jails all the time, and there are times when I'm made aware that one particular person or another is an at-risk kind of an inmate. And so, I professionally am around this kind of stuff all the time. I think your question for me is entering the province of the jury.
So you just don't want to give an opinion on whether you personally feel safe?
I'm not here because of how I feel personally. I'm here professionally.
Did you have an opportunity to review any of his records from when he was in jail?
I don't recall that I did, no.
So would it surprise you that the only information in his jail record is that he's anxious?
Not at all.
And defense counsel brought up the fact that he was in a stressful environment at the jail and yet had no issues. Does that surprise you, given his mental performance on your test?
You know, it doesn't surprise me. It tends to suggest to me that he does well in structure, which fits the hypothesis that he struggles in highly intensive, emotionally laden situations.
I guess what I'm getting at though is that this cognitive deficit that has been established. It seems as though it makes its appearance inconsistent. Is that fair?
Not only fair, I, in my training, come to understand that the hallmark of the expression of brain behavior deficits is inconsistency.
It seems a little coincidental or possibly convenient that the inconsistency also lines up when he's not getting his way.
Well, I think those things are at hand.
Were you hired by the defense?
So I was brought into this case by the defense under a court order to assist with an objective evaluation of Mr. Prado.
Were you paid?
No, haven't been paid.
Okay. So apart from everything, I'm sorry, apart from what the defendant told you, and the little bit of the evidence that you've seen in this case, you haven't received any other literature or any other background information to assist you in reaching any conclusions on the mental, I guess, stability of the defendant.
Yeah, the gravity of this case is obvious. I consulted with two colleagues about my understanding of the data and my formulation.
And you agree with me that everything that we know that he did was a conscious, intentional choice that he made, not one that was something outside of his understanding, correct?
I see no data to controvert that.
So he intentionally chose to grab a gas can and almost set his house on fire. There's nothing that contradicts that.
There's nothing that contradicts that.
There's nothing that contradicts that he intentionally chose to grab magazines out of the back of his car and threaten to get a shootout before the police ever even arrived.
Correct.
There's nothing to contradict that he intentionally chose to go upstairs to his daughter's bedroom and lie in wait and point a firearm at two unsuspecting officers and ambush them and shoot at their chest
Correct.
17 times.
I don't know the number of rounds, ma'am, but I have no reason to doubt that.
Nothing further.
No further questions, Judge.
All right, is this witness excused?
Yes, Judge.
All right, you may step down. The rule has been invoked. You know what that means.
Thank you, Judge.
All right, thank you. Oh, you'll leave the square microphone behind. All right, ladies and gentlemen, if you'll give us 5 minutes.
All right, proceed.
All right, you may be excused. All right, any objections to the charge?
No, you're.
Is that, you want to? Yes.
The one that you gave us this morning.
And counsel, I believe you have it and you want to make your argument about page 6. Yes, page 6. The court will hear your argument.
Judge, the added paragraph about sentences running concurrently is not a statutory requirement for a jury charge. It's surplusage in that sense. It's my understanding there's some case law that says it was an error, but that also confirms that it's not a statutory requirement, and we'd ask the court to stick with the required statutory requirements of a jury charge and not include that surplusage.
State.
Your Honor, it's one sentence that, as the court knows, and as defense counsel referenced, is perfectly permissible under the law. And in a case like this, where we have two separate victims, two separate cause numbers, I think it's important that the jury understands what they assess and how it will be imposed, so that there is no confusion that if they assess 50 years, that he's going to, on one case, and 10 years on another, he's going to do 60. There should be no confusion. So I think it's important that they understand that these sentences will run concurrent so that they can assess a punishment that they think fits both of the crimes at the same time.
All right, defense, I'll give you final argument because you have objection. Is there anything else you wish to add?
No, Judge, that's not a statutory crime. I think jury charges should be statutory. Virtually all those other paragraphs are statutory paragraphs, and so it is surplusage. It's not required, and it's not something that is told to be in. That's something they want to add, but there's no legal reason to do it, so we object on that basis.
All right, the objection will be overruled. Each party will have 30 minutes for argument. Do you want a time announcement, counsel?
Yes, please, can we get a 10-minute mark for us?
10 minutes. And then you wanted 10 minutes. Okay. And are you all splitting your time?
Yes.
Okay. Sure.
I just need 1 second. I'm going to get our power on the TV.
Oh, and Deputy Mejia, do you have the jurors list? Thank you. No, they haven't. I'm gonna have them both do it on record. Yes, we're ready.
All right for the jury.
And Cindy, that square mic there? I got it. No, the other one. Yeah. Can you just put it over there? No, over there. All right, everyone, you may be seated. Thanks, Cindy. All right, defense, any other witnesses?
Defense rests, Your Honor.
State, do you close?
Yeah.
Defense, do you close?
Defense closes.
All right, ladies and gentlemen, I'm going to read to you what is entitled the charge of the court. It's the jury charge. You do not have to memorize it. You'll be given the original back when you begin your deliberations. Members of the jury, after argument of counsel, you will retire to the jury room, select your own presiding juror, and begin your deliberations. As instructed herein, you will fill out the appropriate verdict forms that are attached hereto. I will now give you the law and general instructions that apply to these cases. Cause number 2023 CR 11452. The defendant, Jesus Prado, stands charged by indictment in cause number 2023 CR 11452 with the offense of aggravated assault against a public servant alleged to have been committed on or about the 19th day of October 2023 in Bexar County, Texas, as follows. The defendant, Jesus Prado, did use and exhibit a deadly weapon, namely a firearm, and Jesus Prado did intentionally, knowingly, and recklessly cause bodily injury to Nicholas Swain by shooting Nicholas Swain with said deadly weapon. And Jesus Prado knew Nicholas Swain was a public servant, namely a peace officer, while Nicholas Swain was lawfully discharging an official duty as a public servant, and in retaliation and on account of Nicholas Swain's exercise of official power and performance of an official duty as a public servant. The defendant has entered a plea of guilty to the offense of aggravated assault against a public servant as charged in the indictment and cause number 2023 CR 11452. He has persisted in entering his plea of guilty to this offense, notwithstanding that the court, as required by law, has admonished him of the consequences. The court has determined that the defendant is mentally competent and that he makes this plea of guilt freely and voluntarily to the offense of aggravated assault against a public servant as charged in the indictment in cause number 2023 CR 11452. His plea of guilty in cause number 2023 CR 11452 is by the court received. Cause number 2023 CR 11453. The defendant, Jesus Prado, stands charged by indictment in cause number 2023 CR 11453 with the offense of aggravated assault against a public servant alleged to have been committed on or about the 19th day of October 2023 in Bexar County, Texas, as follows. The defendant, Jesus Prado, did use and exhibit a deadly weapon, namely a firearm, and Jesus Prado did intentionally, knowingly, and recklessly cause bodily injury to Santiago Vizcarra by shooting Santiago Vizcarra with said deadly weapon, and Jesus Prado knew Santiago Santiago Vizcarra was a public servant, namely a peace officer, while Santiago Vizcarra was lawfully discharging an official duty as a public servant, and in retaliation and on account of Santiago's Vizcarra's exercise of official power and performance of an official duty as a public servant. The defendant has entered a plea of guilty to the offense of aggravated assault against a public servant as charged in the indictment in cause number 2023 CR 11453. He has persisted in entering his plea of guilty to this offense, notwithstanding that the court, as required by law, has admonished him of the consequences. The court has determined that the defendant is mentally competent and that he makes this plea of guilty freely and voluntarily to the offense of aggravated assault against a public servant as charged in the indictment in cause number 2023 CR 11453. His plea of guilty in cause number 2023 CR 11453 is by the court received. You are therefore instructed to find on the verdict forms immediately following this page that the defendant is guilty of the offense of aggravated assault against a public servant as charged in the indictment in cause number 2023 CR 11452, and that the defendant is guilty of the offense of aggravated assault against a public servant as charged in the indictment in cause number 2023 CR 11453. After filling out these two verdict forms, finding the defendant guilty, you will then consider the charge of the court on punishment and proceed with your deliberations on punishment. Charge of the court on punishment. After finding the defendant guilty as charged in the indictment in cause number 2023 CR 11452 and guilty as charged in the indictment in cause number 2023 CR 11453, in accordance with his pleas of guilty, you will now assess his punishment for these offenses. You are instructed that the punishment for aggravated assault against a public servant as charged in the indictment in cause number 2023 CR 11452 and as charged in the indictment in cause number 2023 CR 11453 is confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. Therefore, you will assess the punishment of the defendant at life or any term of not more than 99 years or less than 5 years in each case. In addition to imprisonment, an individual found guilty of the offense of aggravated assault against a public servant as charged in each indictment and cause number 2023 CR 11452 and cause number 2023 CR 11453 may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your punishment verdict in each case. If you assess a fine, it is not paid to the victim or victims, if any, but is paid into the registry of the court. You are also instructed that the sentences in each case will run concurrently. The defendant has applied on written sworn motion for community supervision, stating, among other things, that he has never been convicted of a felony in this or any other state. Community supervision means the placement of a defendant by a court under a continuum of programs and sanctions with conditions imposed by the court for a specified period during which a sentence of imprisonment or confinement, imprisonment and fine, or confinement and fine is probated, and the imposition of sentence is suspended in whole or in part. Our statute provides that where a defendant is found guilty of the offense of aggravated assault against a public servant, as charged in each indictment in cause number 2023 CR 11452 and cause number 2023 CR 11453, and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision, it will be granted by the court. If you recommend that the defendant be placed upon community supervision, The court shall determine all the conditions of community supervision and may at any time during the period of community supervision alter or modify the conditions. The court may impose any reasonable condition. You may not recommend that part of the period of confinement be served by incarceration and part by community supervision. Should the punishment assessed by you include a fine, a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. General instructions. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about these cases. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about these cases, or to conduct any research about these cases until I accept your verdicts. After you have reached a unanimous punishment verdict in each case, the presiding juror will fill in the appropriate forms attached to this charge and certify to these verdict forms by signing his or her name as presiding juror. If there is any evidence before you that the defendant may have previously committed an act of misconduct other than those for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed such other act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act of misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements in reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of this trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in each case. No such indication is intended. You are instructed that the defendant may testify on his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. During your deliberations in these cases, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with these cases, which is not shown by the evidence. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a punishment verdict in each case, each juror must agree to that punishment verdict. but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. In the course of deliberations, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is erroneous. However, no juror should surrender his or her honest conviction as to the weight or effect of the evidence solely because of the opinion of his or her fellow jurors or for the mere purpose of returning a verdict. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed in each case to fix the same by lot, chance, any system of averages, or any other method than by full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms for your punishment verdicts are attached for your convenience if you care to use them, but they are not intended to suggest to you in any way what your punishment verdict should be. At any rate, each punishment verdict must be in writing and signed by your presiding juror. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each party will have 30 minutes to address you with their closing arguments. State, are you prepared to proceed?
Yes, Your Honor. In the world of Jesus Jesse Prado, he's the victim. He's the victim because his wife was unfaithful to him, and he's the victim because he lost his brother, Noel Cantu. And he's convinced himself that this self-victimization that he's experienced from issues that everybody in this courtroom has experienced, and the story that he is trying to sell to you all, is that his self-victimization justifies the victimization of two innocent San Antonio Police Department officers. And ladies and gentlemen, now the decision is yours, okay? Is this a community that you want to live in, where someone can ambush two police officers and then come into court and ask you to excuse his behavior because he has experienced issues that each and every one of us have gone through? His behavior on that day was inexcusable by law and in this courtroom. And we are going to ask you to hold him accountable with an appropriate punishment verdict in this case. Now, I'm going to talk to you all about the charge of the court. So when you retire to the jury room, you'll have a copy of the charge with you, and you are instructed to find the defendant guilty on the verdict form. So for the first cause, the cause ending in 5-2, you're instructed to find the defendant guilty on the verdict form on page 4. And then for the cause number ending in 5-3, you're instructed to find him guilty on page 5. And that is due to his plea of guilty that he made before you all in open court at the start of this case. Now, I want to be clear to you all. The defendant's plea of guilty is tactical, Okay, it's not him taking accountability. If you look at all of the evidence that the state has presented to you over the past week, it is undisputed, the acts that occurred. Okay, and so just as he presented himself as a tactical expert and wanted to comment on the tactics of the police officers that he ambushed on that day, that is a tactical decision that he has made, knowing that he is going to come to you all and ask for probation or a light prison sentence. And you all need to take that under consideration in your deliberations. Now, after you fill out the verdict forms finding him guilty, you're going to move to the charge of the court on punishment. And the range of punishment in each cause is 5 to 99 years or life in prison and up to a $10,000 fine. He is eligible for probation in each cause because he's never been convicted of a felony. Okay, but we're going to talk about that. First, you must know that the sentences that you assess against this defendant are, by operation of law, going to run concurrently. So what that means is that they will run at the same time. If you assess a punishment of 60 years for his conduct against Officer Swain and 60 years for his conduct against Officer Viscara, he is going to be serving one prison sentence of 60 years because the time is going to run at the same time. Now, in the charge of the court, it says the jury may, within its discretion, recommend community supervision. To do so, to assess community supervision in this case, you would have to assess his punishment. So that means the punishment that you would want him to receive if he was placed on probation and messed up, okay? You would have to assess punishment between 5 to 10 years in prison and grant his application. And you all have no say in the conditions or the term that he's going to be on probation. You only have a say in that underlying sentence, should he mess up. And so this is severely limiting you regarding the range of punishment, because the full range is not on the table anymore. So we know that he has already committed these heinous acts. And so you would have to find that what he did to Officer Swain and Officer Viscara is only worth a second shot out in our community. And then if he messes up his second shot, he's only going to face 10 years in prison. Ladies and gentlemen, that is highly unreasonable. And so let's just consider what that would look like should you grant his community supervision application. One, it means that he's going to be released back into our community. He may have to report to a probation officer monthly. He's may be ordered to not possess firearms, but you heard the testimony of Dara Salazar. There's no way to really enforce that. If he's caught with it, he's caught with it, but there's no one that's going to go ensure that he's not possessing those firearms. There's been no testimony about substance abuse issues, so that's not a term that would likely be assessed against him. Okay, he may not qualify for the mental health inpatient treatment, and possibly there could be a no contact order with Officer Swain and Viscara. And should the defendant violate this second chance, the state must prove the allegations in a hearing before the judge, and the maximum punishment for a second chance on a heinous offense would be an underlying set by you, and the maximum could only be 10 years. That's unreasonable. I want to impart on you all that probation is totally reactionary, okay? There is nothing that probation can do. There's no condition that they can set to ensure that the acts that occurred on October 19th of 2023 won't happen again. The evidence that you all have seen in this case does not support a prison sentence of 5 to 10 years, and it definitely does not support a recommendation of community supervision. There is only one way to ensure that the defendant does not have access to firearms or does not have the ability to cause harm in our community, And that is for you all to deny his application for community supervision and sentence him to a lengthy prison sentence. The goal in your punishment assessment needs to be to protect our community, our law enforcement officers, and the victims that are listed in the indictment, Officer Swain and Officer Viscara. And I want you all to recall the testimony of Officer Swain and Officer Viscara. Okay, they're both back on the police force. They're both back out there responding to calls for service and helping and protecting our community. There's only one way to ensure that the defendant does not run into them again. There's only one way to ensure that they're not dispatched to his house if he messes up, if you give him a second chance. There's only one way that Officer Swain can ensure to his son that his life is not ever going to be at the hands of that defendant sitting over there. And that is for you all to send him to prison. Provide their families this peace of mind. Regarding the acts of misconduct, we have proven them beyond a reasonable doubt. And these acts of misconduct, that slap of Monet, they've been proven beyond a reasonable doubt. Okay, he admitted it to his own daughter. And we've kind of heard some, well, it wasn't, it was just the backhand. Ladies and gentlemen, that is a violation of law. Okay, it's a pattern of escalating behavior, of him not getting what he wants and lashing out at people. Now, you are the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to the testimony. And so I want you all to think about all of the witnesses that you've heard testify on behalf of defense over the past 2 days. Okay, they all had some deep-rooted relationship to the defendant, though the defendant did hide many parts of himself to all of those witnesses. And so you need to think about the motive that they have to take the stand and testify on his behalf. If you think about the testimony of his sister, she didn't even want to concede that slapping someone was a bad act. Is that testimony that you should take under advisement? You're the judge of that. But regarding parole, okay, you may consider the existence of it. Now, the defendant's length of the sentence may be reduced by parole being awarded. Now, he would have to serve half of his prison term before he became eligible to apply for parole. So should you assess a sentence of 60 years in this case, he would be able to apply for parole at 30 years. He may or may not get it. We cannot accurately determine what the parole board is going to do, okay? Now, you've heard testimony from many witnesses that you cannot judge someone by the actions that they take
10 minutes.
on the worst day of their life. And I submit to you that you can, because if you look at the acts of this defendant on the worst day of his life compared to the acts of the officers, that day was the worst day of their life, having to be in the hospital and get treated. And what did they do? They buckled up, they strapped in, and they went back out there to protect our community. Now it is your time to protect them. Your Honor, I'm the reserve.
Defense.
There is no excuse for what Jesse did, and he is not the victim in this case. And no one that we brought here today to testify, or yesterday as well, said otherwise. Jesse did what he did, and there is no excuse for it. There is no justification. Officer Swain, Officer Viscara, his family, their families, families in that neighborhood, they're the ones that have to recover after this. There's no doubt about that. No one here is suggesting otherwise. The reason we are here is because Jesse has taken accountability. He has taken responsibility for what happened. He did when it happened in the interview with the detective, and he did when he pled guilty to y'all, the members of the jury. 12 members were going to decide his fate. That's why we're here. And when it comes to assessing his punishment, yes, you're going to have to consider those horrible actions that he made on the worst day of his life. Absolutely, because there has to be punishment for that. We're also asking you to consider the 40 years prior that Jesse Prado lived until that moment, because that day was one day. And the bad acts that the state's referring to, all happened within a calendar year, 9-month period after finding out that his wife had an affair on him and was trying to leave him. That's the frame in which this time exists. Before I go on, I want to also go over some of the jury charge as well. Megan went over some of the stuff that I was going to talk to y'all about regarding the probation. Just to reiterate, probation is on the table because Jesse has no prior felony convictions, and in fact, he's never been arrested before in his entire life until this day. And that's what the Texas legislature, who is not friendly to criminal defendants, has decided, knowing that this was a possibility, that somebody who shot a police officer could be eligible for probation. That was the Texas legislature's decision. And so that is why it is in front of you. And so look, we get that for not for everyone, probation would be on the table for a case like this. That's why we talked about it so much during jury selection. And y'all made it onto this jury because y'all answered that you could consider probation if appropriate in certain circumstances. So that is why it is here. That is why it is on the table. Regarding the prior bad acts, Megan's right. They have to prove them to you beyond a reasonable doubt. Anything that's not pled guilty to by Jesse or found guilty to during a trial, you have to be proven beyond a reasonable doubt by the state in order to consider it against Jesse. And the slap, yes, that is undisputed. That is undisputed. That has been proven. And again, January of 2023, month that he found out that his wife had an affair. Not an excuse, but the context of which this happened. It's undisputed. But regarding a lot of the other stuff we talked about during the trial, there is some dispute. I want to focus in a little bit on one of them, which is regarding this attempted arson. You heard from an arson investigator in this case. And that was probably really the only witness where things got even like a little contentious with regards to our questioning of him. And the reason is because he was talking about absence of evidence, not meaning the see, I'm switching up my own words here. The fact that there wasn't physical evidence, he was saying wasn't proof that there wasn't evidence. And I want to refer you to specifically a lab report where there was not gasoline found on the entryway into the residence of Jesse's house. And he said, well, that doesn't mean that there wasn't any gasoline there. That's what their detective or investigators said regarding arson. That's a scientific conclusion that he just disregarded. And so with regards to attempted arson, yes, there was evidence that there was gasoline on the driveway, in the garage, and there was testimony that by Monette, that Jesse at some point went down with a lighter, and she said she kicked it out of his hands before he could light the ground, right? That was the evidence regarding attempted arson. But as Mr. Acevedo was trying to point out to the investigator, there was really no evidence regarding Jesse's state of mind, the intent behind it, okay? So again, that's something the state had to prove beyond a reasonable doubt before you can consider that against Jesse in this case. And regarding some of the other facts that happened on the day they were all here for, there's been a lot of discussion about a 911 call. And you have the 911 call in evidence. And you can listen to it back in the jury room. And most of what's on that 911 call, you can hear crystal clear, okay? But then there's this discussion about what does Jesse say at a certain point. They say he says shoot or shoot out, or something to that effect. And the Detective Soto, said he's 100% sure. He told you 100%, but that's what Jesse says. Go back and listen to that, because it's not clear what he says exactly. It isn't. And on that note, go back and watch Officer Viscara's body worn cam, because when they first show up to the scene, they are walking towards the residence, and he says, or one of the officers say, "Do you smell it?" They smell the gasoline. And then as they're starting to walk towards the residence, they turn around because Monette's coming. And they talk to Monette. And in that moment, there's no mention he said he's going to have a shootout. She never tells them that's what Jesse told her. The only mention of weapons that comes up is when, I believe it was Officer Viscara, asks Monette, does he have any weapons? And she says yes. And that is the only time weapons are mentioned to any of the first responding officers. It's not mentioned on the incident detail report that they had when they were going to the scene. And it's not mentioned by Monette to the 911 operator. And it's not mentioned by Monette to the officers on scene when they first arrived. And so it begs the question, when something, oh, and Monette doesn't mention it to the detective when he interviews her. She admitted that on the stand. I never said it to the detective. And it begs the question is, why didn't she say it if it happened? And again, like, the fact that she didn't say it is not to say that she could have prevented what happened. I'm not saying that. But they focused a lot on that shootout to try and say that Jesse planned this, that he was intending to do this for at least minutes leading up to it. But it's not, that is not proven beyond a reasonable doubt. Another thing that came up was a jail call. Okay. And you heard the jail call. It was between Jesse and his best friend, JP Carrasco, who testified as well. And this mentioned by Jesse that he's $1 million weapon. Okay. You've heard the testimony that his bond was set at $1 million. And JP's opinion regarding that was that Jesse was trying to cheer him up, because that was something that he would do oftentimes, especially given that situation where JP is calling him for the first time since this all happened. And it's several weeks later. The reason I mentioned that, though, besides to say that's what Jesse was intending in that phone call, not to make light of the situation, but to cheer his friend up, is that, you know, Jesse's been in custody for over 2 years. He's made thousands of jail calls. They brought you one jail call where they're trying to imply a lack of remorse on his part. The district attorney's office is more than just these two prosecutors, who are incredible prosecutors who presented a case to you over the past week or so with all this evidence and all this testimony, with the support of investigators and paralegals and other prosecutors who probably worked on this case before they did. They brought you one jail call with the thousands of jail calls that were available for a reason, because that's all there was.
Object to facts, not an evidence, Your Honor.
Ladies and gentlemen, you remember the evidence as it's been received?
What I mean is there was nothing so egregious that Jesse's ever said on a jail call that was worthy of bringing you. And that's consistent. The reason I mention is that's consistent with what we know about Jesse Prado. That he's lived a life of 40 years, not getting in trouble, not being a gangster, not being a career criminal, not being somebody who hurts people. He's been a good man for 40 years. And that has to mean something, ladies and gentlemen. That has to mean something. That is the core question of this case. There's been discussion about closed doors and what happens behind closed doors, because not everyone who knew Jesse saw him behind closed doors. That's definitely true. Monette definitely saw him behind closed doors for the 20 years they were together. And what did she tell you? That until January 2023, there had been no domestic violence.
10 minutes.
That there had been no real issues in their marriage that ever got to this level. And besides, as she described it, arguing with bills and so on, for 20 years, behind closed doors, Jesse was the same man that all of his family, all of his friends, all of his neighbors, the jail guard, they all told you he was. That is consistent with his character. And there's no doubt y'all have an incredibly difficult decision in front of you. And when it comes to the reasons that we punish, we talked about it during voir dire: retribution, rehabilitation, deterrence. You should consider all of those in making your decision. You should consider all of those when you're thinking about what kind of message do I want to send to the community? Because I anticipate the state's going to get up here and they're going to tell you to send a message to the community that you back law enforcement. And absolutely, that's a message you probably should send. But another message you should send is that in Bexar County, we consider not just the worst time, the worst decision, the worst point of someone's life, that we also consider everything leading up to it and the man that somebody was before we throw him away and lock up the key. I ask that you consider both when you assess Jesse Prado's punishment.
All right, state.
Judge, sorry, I reserve the rest of the time for Mr. Acevedo.
All right, thank you.
May I go, Judge?
Oh, yes,
Thank you.
you have 18 minutes, counsel.
Good afternoon, ladies and gentlemen. I do want to thank you for your time. I asked you to listen to the whole case, not just the first few days. Jesse, thank you for your time. This is Judgment Day for him. And I tell you, this has been a difficult case for me. And I do like to talk to jurors in closing. I'm the older man in this courtroom now because I've been doing this for 31 years, seen a lot of trials. I've represented police officers in their criminal cases. I've represented people who have been accused of hurting police officers. And I'm telling you, this case has been really difficult for me. Because the problem with this case is that I have somebody that I have figured out over the last 2 years is a really good man. He really is. He really is. And I'm going to talk about that. And he did something really bad. I have family that's law enforcement too. I do back the blue. Now I also check them as a defense lawyer. I mean, I've caught police officers lying and things like that. But I understand the bravery it takes to go to a call. I understand the bravery it takes for their brothers to do extractions when there's a gunman who has not been apprehended. I understand all that. That's why it's so damn tough. You know, this in a punishment trial, this is what the state's supposed to do. It's 404B, it's the legal term. This is the chance for them that, you know what, we're going to tell this jury about every bad thing your client has done. He was a teenager, he broke into a house, and then he got into bar fights and he, used drugs, he sold some drugs, or, whatever the case may be. Like 404B is what punishment is usually about, because the crime gets presented in the trial, and then we tell you, like, this guy's a bad guy, this is what we need to do. And believe me, we've seen some bad guys. We have. I've seen people that are sociopaths. I've seen people that were mean. I've seen people that the community really needs protecting from. And the problem with this damn case is that Jesse isn't that guy. He isn't. And what do I mean by that? What's the point I'm trying to make about that? There's not one person who could say a bad thing about Jesse in this entire trial. Besides, I mean, the obvious thing we're here for that he's pled guilty to, the shooting is horrible. But I'm saying outside of that, and then the marital relationship for that year where, okay, there's this one slap with the infidelity, and then those real ugly comments that Bonnet says he made all during the time of the 18th and 19th when he's having this breakdown. Because the truth of the matter is, there's not one person who can say he's ever been mean in his life. The only things that we've heard, and they're uncontested, and believe me, with the team the DA has, the biggest law firm in San Antonio, they can go under every rock. The only thing we know about Jesse is that he's hardworking, he's kind, he's friendly, he's generous, he's loving to his girls and to his wife. He's dedicated, he's faithful, he's supportive of his sons, or his son and his best friend JP. He's been a firefighter, he's been a first responder, he supports his military son, he supports his military best friend. Like every single bit of evidence about who this man is for those first 20 million minutes of his life, 40 years, was that he did everything right. A blue collar guy who was trying to make it up in the world and went from the trailer up to the suburbia neighborhood house that he had to work his ass off to get to. But he did it with a loving family, a loving wife, faithful man, not one single problem in his life. Not one person who could say those first 40 years of his life he ever did anything bad. I've never seen a trial where somebody did something bad and nobody could say anything bad about him up until the divorce, the infidelity, and the shooting. Not one thing. That's why it gets me so frustrated. Because what do we do? I know they're going to ask for a big sentence because this is You know, Joe Gonzalez is our DA. They do press conferences. Police officers got shot. This is going to happen. Like, protect our community. Big sentence. But I try to look at it in a bigger picture because there's no excuse for the damage that was caused. I wish there's something I could do to have changed it. If there's a case where I wish I had a time machine, I wish I could go back and stop all this from happening. Because none of it was good. None of it was needed. None of it was really wanted. Madison talked about this perfect storm, and that's kind of how I see it. Because everything kind of went bad for Jesse in a way where I think his control over it was kind of limited. Because a person that has never done a bad thing in his life, who's been, like I said, just outwardly friendly. I mean, I'm not friendly in the grocery store. If I saw you in the grocery store, not knowing you, I'm not going to come up to you and start a friendly conversation. It's not my personality. I'm a serious guy. I love my family. I do things like that. But when Jesse's training, whether it be military guys in the oil fields, or whether it be guys to get out of prison, because the oil fields have everybody, especially when the money's good. And his trainees say, I want to be like you, Jesse Prado. Those are the stories that we hear about him over and over and over again. And then he found himself in this position. I wish I had a better explanation for it. I do, because it doesn't make any sense. And if somebody's saying that he hadn't had 20 millions of a really good life with really good behavior, full of love and everything else, they're lying to you. So we get to this year. And, I appreciate Dr. Jumis. He was court appointed by the court. I mean, per my request, I asked for him. He got appointed by the court to do this evaluation. And, he's an honest guy. I've known him for 15, 20 years. And I think a lot of what he says is absolutely true. There's the trauma of his brother. Depression by itself doesn't generally bring on violence. That's all true. I mean, suicide, but it doesn't make you go out and hurt people generally. And so then there's the issue of what he called the cascading of bad things, in his life with his wife, Monette, and the idea of like losing everything, being behind on the mortgage, feeling depressed, being, strung along in this back and forth with Monette, where he's like, yeah, let's make this work. And then it kind of going back and forth and not working. The separation, having the pressure of mortgage payments behind. The behavior a week before where now he starts calling into work, which is as unlike anything possible with Jesse as anything. I mean, the one thing that man was crazy about was working. That's what he did. There's just no dispute about that. And so something's going on. There was some kind of mental break because there was no reason to shoot these police officers. There was no rational reason for it. And I have a spot in my mind because I've seen so many people with all different kinds of mental health issues. Just Texas doesn't do a good job. Society doesn't do a good job of trying to find resources for people that are having crisis. And in crisis, bad things can happen. But there's such a big difference when it's a bad person who's not having a crisis. But there's some people who just don't care whether they hurt somebody else. There's some people that don't think it's wrong to assault a police officer. I mean, there's so many things that exist in the world that don't exist at this table over here. And so, what do we do? What do we do? What do we do if there was a perfect storm and a good person did something really bad? Well, falls on y'all. I can certainly give my opinion for whatever that's worth. I've seen a lot. Is this a max case? And understand the law is 60 to 99. Okay, that's all the same. So the punishment range is kind of 5 to 10 for probation, 5 to 99 for the punishment. But understand 60 to all the way to 99 or life is the same. So 60 on up is the max. That's the max. And so if you think of that line of 60 to the max, it means you're going to be in prison for minimum 30 years, probably significantly longer than that. And so this is where I ask for perspective. I mean, 10 years in prison is a long time. People don't get rehabilitated in prison, in my experience. They don't offer mental health treatment. They don't offer medical treatment. It is a place for punishment and to house people that can't be safe in society.
Your Honor, that's all facts, not an evidence.
Overruled.
And so, it's hard time. It's hard time. We can throw people away. We throw some people away. And I'm asking you not to throw Jesse away because this case is different. It really is different. A 60-year sentence or anything above that is pretty much a life sentence to him where he'll be expected to die in prison most likely. You have to understand, like, even a 30-year sentence, okay, well, that kind of takes him to his life expectancy. So a 30-year sentence can be a near life. The average age for a man in the United States to die at, I think, is 74, right around there somewhere. And do I think a life sentence is appropriate for Jesse? I don't. I'm going to ask you to consider not doing anything in that realm, considering the fact that his life has been a very good one, not just a normal good one, but a very good one. The 20-year mark for him kind of puts him to that Social Security age. 10 years is hard time. He is eligible for probation for a reason because he's the circumstances of his life give him that opportunity. But the only people that can give that to him is him. I have seen probation help a lot of people. Probation can help people. And as far as whether or not the prosecutors think probation can be safe for somebody, this judge is a no-nonsense judge. She has that reputation. She's actually one of the judges in charge of the mental health court. She's as familiar as anybody in the courthouse with mental health conditions and the programs. She has the ability to put people on monitor. She has the ability to put people in jail whenever she wants if they're on probation. She has the ability, and this one's automatic. The firearm thing, he's a convicted felon as soon as you sign that jury form. At that point, if he gets caught with a firearm, he's committing a serious felony and he's not eligible for probation from a jury on something like that. So it's absolutely 100% a condition that you can't have a firearm while you're on probation. And he would be a convicted felon. That would be a separate crime. Can they check on him? Yeah, they can check on him. They can do house visits. They can do weekly reporting. They can do monthly reporting. This judge can put him in mental health treatment. Those are things that can help him. Dr. Dumas is absolutely right. Would further evaluation help him? Would treatment help him? Are there programs that can help him come back into society in a fruitful way and be a productive member of society? That's the possibility. And don't misunderstand too that if you give them a chance like that, the judge of the court, in his case decided to the 187th, upon any violation, can sentence him to prison if it's 10 years probated. And again, 10 years is a long time. It is.
Oh, counsel, let me pause you just one moment. Do you need water or anything?
I have water. Just that cough.
Do you need a cough drop?
Lots of cough. Thank you so much.
All right, thank you. You may continue. Sorry for the interruption.
If anybody needs to pause, just please stop me and we can take care of anything you need. I do believe in second chances. I do. I've seen too many success stories not to. The thing about a second chance is if you don't take advantage of it, you go right into prison. I have seen people waste their second chance and they do time. That happens too. But I can tell you on paper, Jesse's one of those guys that has a much higher chance of success. And how do you know that? Well, we talked about the first 20 million minutes of his life. We can talk a little bit about the last 2 million minutes of his life because these last 2 years in jail, I have never had a jail guard come testify for an inmate. 31 years. 31 years. It is virtually impossible to do 2 years in administrative segregation without a write-up because the conditions are just horrible.
All right, that'll be overruled.
It's just not common. You're living in a cell half the size of this jury box, a bunk bed, a toilet, and a metal desk, all metal, all stainless steel metal. It is what it is. It's miserable conditions. It's only for a very small percentage of the jail population. But he's been in that psychologically tough situation for 2 years because of the nature of his charge and how high his bonds were. So it's kind of automatic for him. And I understand he put himself there. I'm not trying to apologize for that. But what I'm saying is if you can exist in those conditions for 2 years with a single write-up, where even a sheriff's deputy comes and testifies on your behalf, like, yeah, this guy, not a problem, completely compliant. That's how you know that it's that first 40 years was sincere. It was right. When I tell you he's a good man, I'm not lying. I mean, he is. And when I tell you that these officers didn't deserve it, I mean that too. It's why I don't like this case. I mean, it really is. Because, like, yeah, it shouldn't have happened. Good people should not have done a bad thing. They shouldn't have had to suffer for it. And, you know, it would have been so much better if he could have gotten a little bit of help if they just to figure out when he felt that cascading loss, that feeling of losing everything, as Monette said, snapped, or as Madison said, a perfect storm of just problems that fell them in the wrong time. There is some hope. There's some hope. Do I worry about him being a danger in the future? I don't. I really don't. And that's partly experience. I mean, knock on wood, it's the same kind of feeling where I don't think I'm going to find that any kind of serious trouble in my life at my age. I'm pretty confident. Now, can anything happen? Yeah, anything can happen. But I'm as confident about Jesse as I am about myself, getting to know him, the history. It's too different. It's too different from the average to below average person when it comes to criminal intent
3 minutes.
and criminal intention. And that's what I'm asking you to consider. I have seen people get thrown away in this system. Some people deserved it. But, you know, if you do this long enough, you're going to see some injustice. And I don't know how to portray this case to you because it's as simple as I said to start. Man, this is a hard one. It really is. It's hard. I don't like it. I don't like having to argue, like, look at their wishes. I really don't. I wish it had never happened. I really wish it had never happened. And what do we do with him now? I'm arguing to you. I'm suggesting to you that if you gave him 10 years probated, having known he's already served 2 years and 2 months of virtual solitary confinement in harsh conditions and with zero problems, that it gives you some solace that he can make it. There's evidence that he can make it and he can follow the rules and do what he needs to do. He'll always be a convicted felon. He'll never be able to own guns again legally in Texas. It'd be a felony offense if he possessed one at all on any level. And I understand, like, you know, some people might feel that's okay and some people might not. That's why we have 12 jurors, you know, to consider all these things. But if you feel it's something that's appropriate, we'll explain it, argue it. The jury charge tells you to hold on to your convictions if you think something like that's appropriate. If you don't think that's appropriate, well, then what's the number? You know, do we throw him away forever? You know, do we give it the 30 years, puts him at his life expectancy? 20 years puts him at social security age. 10 years gives him some years where maybe he could see his youngest daughters, you know, get married or get their professions. I just don't think a person with this kind of history and this history of good character outside of one very isolated incident is a case where it's anywhere near a maximum sentence. That's why he's probation eligible, because the guy has had pretty exemplary life outside of this horrible thing that happened. So that's what I'm going to ask you to consider. Melissa's a good prosecutor. She's going to present, you know, the horror of the case. You know, I can't respond to anything he says. Like, I have to sit down and she gets the last word, which I never thought was really fair, but that's the way it works in Texas in this system. I just ask that you consider, like, yeah, what would the defense have to say about that? Because, like, yes, we agree it's all horrible, and you can play it, and you can show clips of the blood and the guts, and it's all true. We're not hiding from that. But Jesse gave himself up. I mean, he shot for about 15 or 20 seconds, and that's the damage done to the officer. There were 2 shots later at the car. In the end, I don't know how significant that is, but it was that 1 minute that damage was done. That was the minute. All the bad talk before, that was all part of the mental breakdown, because all those messages and the stuff about the daughter who he adores and has never come close to hurting his entire life
Fine.
was all part of the distress, the mental breakdown. And I'm just going to ask that you consider that and find it for what it's worth. And thank you for your attention.
All right, state, you may proceed.
I want to make sure it gets
Sure.
set up now.
And may I have a 5-minute one?
Yes. And you have 19 minutes and 40 seconds.
In my opening statement, I told you that you were going to hear that Jesse Prado is a man who, when he's faced with the greatest adversity, instead of finding a healthy way to deal with it, he lashes out and he blames others. And that 911 call is a perfect example, because you can see that all Monette wants is to walk away. She doesn't want to have the conversation that she's had with him over and over again. And last time I checked, she's allowed to decide she does not want to be married to him anymore. But that made him mad. He wasn't getting his way. And so he took a gas can and then tried to light his house on fire instead of in front of his daughters. And then you can hear him on that 911 call say, "You did this. You fucking did this." And then he did this and this. And he didn't do it to them because of anything that they did to him. And it has nothing to do with the loss of his brother. I don't doubt that that was hard on him. And I am sorry to him and his family that they lost Wedo. I am. I'm sure that was hard on him. But it was 2 years before this happened. This had nothing to do with a car accident that he was in over 16 years ago. This was because he was upset that Monette was leaving and he wasn't getting his way. And if he is capable of doing that to these officers who were just there doing their job, what risk does that put the rest of us in if he is out in society? What risk does he pose to the community if he can jump to this? Because he is experiencing the same stressors and the same hardships that we all experience every day. A person who can do that does not deserve probation or a low prison sentence. So let's talk about why. What did the defense bring you in their case? Did anybody that testified for the defendant say he actually felt bad? No. They said he knows what he did was wrong. They said he's a good guy. But no one actually said he felt bad about doing it. The only time we get anywhere close to remorse is when he is in the interview with Detective Martinez, and he tells Detective Martinez, "My fight wasn't with them. I messed up." But he follows that up with, "If they hadn't approached me wrong, we wouldn't be here. They approached me wrong. They took tactical positions on me. That upset me." He never said he felt threatened or in fear for his life. He was upset. That's not accountability. That's not remorse. That's more victim blaming. And unless we think he's never going to get upset again in his life, he is a danger to the community. They brought up his lack of criminal history. But doesn't that make what he did all the more alarming? He is a bomb that went off and caused mass destruction. And what's more scary about that is the reason he went off are the same stressors that affect every one of us every day. There was no unusual occurrence that brought this on. These are normal everyday things that we all have to figure out how to cope with. We don't get to run around hurting people and then say, "Oh, I've been having a hard time, so let me back out and I'll try to do better. Believe me, everybody said they never thought he could ever do this. His sister swore on her life. I would have sworn on my life he would have never done this. And then he did. So she can't swear on her life now, he never will again. They said he admitted to what he did. He's here taking responsibility. But is he? Really? I told you in my opening, you were going to hear that he admitted to what he did. But only as much as he had to. Because the writing was on the wall. You can see on that video, he only stops shooting at them because Officer Bexar shoots back. He has to take cover, so he can't continue shooting. And then when Officer Bexar is safely inside, he chooses to shoot 2 more times. He is brazen enough to shoot 2 more times. I respectfully disagree with Mr. Acevedo that doesn't really tell us anything, that he shot at Monette's engine block. Because he saw the cavalry coming, and he still shot 2 more times. And I want you to think about him shooting Monette's car, because he told Detective Martinez, my fight wasn't with them. No, his fight was with Monette. So him shooting at her car is what, a metaphor? Because he would rather be targeting her? She is who his fight was with. So if we would not excuse him doing this to her, if we would not excuse him or put him on probation or give him a slap on the wrist for shooting the mother of his children because she's the one who his fight was with, we absolutely should not consider it for shooting 2 innocent officers who were just there to help. He did not own up to what he did. Not unequivocally, not without reservation, because he blames them, and he blames Monette, and he blames the hardships in his life, because he's got to be the victim. And his taking accountability wasn't entirely sincere, because he wasn't honest with the detectives in that interview. He told them, I was going to come out and talk to them. I only pulled out my rifle and did what I did because they pulled out a rifle on me. They approached me wrong. But that is crap. And you know that from that 911 call. I beg you, go back there and listen to it and put on headphones, because you can hear him say, you call the cops on me, I'm going to be in a shootout. And you know that it's true because Monette told Carol and Carol told y'all that Monette told her Jesse threatened to be in a shootout. There was a lot going on. I think it's totally understandable that that's a piece of information that Monette might have forgotten to tell the detectives in the multitude of other things that she had to tell them. But Carol told them that Monette told her, and then Carol came and told you. And then that is corroborated by the fact that Monette told you she saw Jesse getting magazines out of the back of his car and going inside and locking himself in before the police ever arrived. He was preparing for this shootout. That's backed up by the evidence. Now, defense wanted to cross-examine Monette and try to get her to say, well, couldn't he have just been saying that he was shutting his liftgate on the back of his car? Well, no, because when the police get there, the liftgate is open. So that's not what he was saying. And before the police got there, when they're fighting in the driveway, the liftgate is down. So he said, I'm going to be in a shootout. And what Monette told you is true. So he did not own up to what he did. He's doing more victim blaming, more pointing the finger at other people, because he doesn't want to take accountability for what he did. Then he brought multiple people to talk about his character. And ladies and gentlemen, I think it's pretty clear across the board, from the friends who kind of only know him from the neighborhood or through Facebook, as well as his own family. They didn't know him. They didn't know what he was capable of. They didn't know what was inside of him. But we know now. And they also brought you the jail guard to say he's been a good guy in the jail the last couple of years. But ladies and gentlemen, the last couple of years he's been in there, He's had 5 to 99 hanging over his head. So of course he's going to be on his best behavior. That is not the best metric for you to decide whether he is going to be a productive and safe member of society when he gets back out into the free world, because he's in ad seg the majority of the time. He's not exposed to the same kinds of stressors that he had to deal with and would continue to have to deal with if he were to be released out into society. That's not a fair way to measure how he's going to behave when he's out in the free world. No matter how much his family loves him or thinks that he has done good things, been a good guy in the past, it cannot undo what we now know he is capable of. They told you that he's the kind of guy that would give anybody the shirt off his back. They said that multiple times. But look at what he did to their shirts. Look at what he did to Officer Bexar's shirt and Officer Swain's shirt. If he hadn't been wearing that vest, his shirt would have been destroyed. That vest and that body cam, these are the only reasons that we're not here for a capital murder. Because he's lucky. This isn't because he didn't try. It's because he's lucky. And because Officer Swain had the strength of character to save his own life, and because of all the medical personnel who intervened to save his life. They also brought up the car accident, the head trauma. Dr. Dumas testified. He can't tell you why he might have some decision-making issues based on that testing. But he also can't tell you how bad that is. He said the one test he gave him was one small facet of a person's decision-making ability. And on that one test, he did bad. But that's not the whole story. He didn't do all the testing. And so he's a bad decision maker. He also couldn't tell you if that's something that came as a result of a head injury or if he was born with it. Are we supposed to bear the burden of him being a bad decision maker and just hope and pray that he doesn't lash out at somebody else the next time life gets hard? That cannot be the kind of society that we want to live in. That can't be the kind of message that we want to send to the community. The car accident was 16 years ago, and there's no evidence there's been any intervening trauma since. And his son and Monette, who know him better than anybody, said after those accidents, he was fine. They never saw any personality issues, no problems with him regulating his emotions or handling hard things, making decisions. He was fine. We don't see this kind of behavior until he doesn't get his way. Even the loss of his brother didn't precipitate this. This all came down to Monette, which boils down to his ego. His ego. He was upset that Monette was leaving him. And Detective Soto even told you that in the interview, you see his arrogance shine through. He says, they had bad tactics. They shouldn't have approached me like they did. They were sloppy. And he also said, bless you, Aaron.
Excuse me, sorry.
Okay. He said they had bad tactics. He said they were sloppy. And he said that they shouldn't have approached him like they did. He's blaming them because of his arrogance. That's what this boils down to. He doesn't like that he was told no. He thinks he's $1 million weapon. You heard that on that jail call. And they want to say that that was him trying to convince JP that he's okay, he's doing okay. You heard my cross of JP. There's a lot of ways that you can tell somebody you're doing okay, don't worry about me. Not to joke that you're $1 million weapon after, what, 2.5 weeks of nearly killing 2 officers. When he asked Detective Martinez where he shot Officer Swain, Detective Martinez wasn't sure. And he said, I think in the leg. And again, with his arrogance. Oh, no way. Couldn't have been. I'm too good a shot because I'm $1 million weapon. This all comes down to his ego. He should be punished for what he did and for what he almost did. Detective Soto told you that the number one rule of when you have a loaded live firearm, you don't point it at anything that you are not prepared to destroy. And not only did he load it and point it, he fired over and over and over and over and over and over and over without stopping until he didn't have a choice but to stop. Every single time he pulled the trigger, every single step he took leading up to pulling the trigger were choices that he consciously made, that no doctor can testify that he didn't know what he was doing, that he chose to do. Every opportunity, every one of those choices was an opportunity for him to walk it back and say, no, this is a bad idea. What am I doing? But he kept on going. He should not get credit for the fact that they are still alive, that he was unlucky in his goal. He should not get credit for the fact that he didn't choose to shoot the other officers who came to save their lives, because that's giving him the authority to play God. He gets to decide who he shoots and nearly kills and who lives.
4 minutes.
Giving him probation is giving him the authority to play God. Putting him back in the community is putting a ticking time bomb back out there and just hoping and praying that it doesn't go off again. Because that's what he is. Because anytime he is faced with anything remotely like this again, you never know what's going to happen. So then the rest of society would have to live the rest of whatever 21 million minutes that he has to live on pins and needles, walking on eggshells, worrying. Is he going to do this again? Do I have the misfortune of living next door to him when life starts to pile on? He deserves the sentence that reflects that danger, what he actually did, and what provides them justice for what they went through. We are asking for no less than 60 years, because that is what ensures that he cannot do this to anyone again. And it sends the message to the community that we are not going to tolerate this type of behavior. You don't get to make these mistakes and blame hardships on it. We're not going to set that precedent. We're not going to tell our law enforcement officers that you're replaceable and expendable if somebody happens to have a hard time when they encounter you. Assess a sentence that makes what they went through that day and everything that they have been through since, like Officer Swain said in his testimony, worth it. Thank you.
All right, ladies and gentlemen, you've heard argument and